Guys, this is your Realtor Shan from eXp Realty, and I have Bita Di Lisi from Stonegate Legal Services. So we're just gonna have a chat about what could landlords do and what are the tips and tricks that we need to know as landlords. And Bita, you can take it from there.
Thank you so much, Shen. Good morning, everyone. Thank you so much for having me on the show.
No, thank you for accepting this and coming on. Perfect. So Bhairav, there's all these questions that landlords have and who don't have an answer for. And I know that it's you're one call away and you're always helpful. Anytime I call you, you are easy to reach. If not, the best scenario is just to email you and get a hold of you, right? So when it comes to questions that landlords have, so the main thing is what does landlord need to know when it comes to rent increases? So because everyone's kind of on a lower rent right now and they are looking to increase it, how could they do it?
So let's talk about rent increases because landlords must, well, firstly, landlords have the lawful right to increase the rent every year. Okay.
Yeah.
If they don't do it for whatever reason, they're being a nice person, they don't want to do it, they want to help their tenant, whatever reason. If it's kind of like a use it or lose it.
Lose
They can't go back 5 years and say, well, I didn't increase the rent over the last 5 years. I'm going to do it now,
it. Okay.
right? You can't do that. You have the lawful right as a landlord to increase the rent annually,
Okay.
okay? In order to do so, you must serve your tenants with legal notice. What is a legal notice?
Mhm.
Legal notice is either an N1 notice of rent increase
Okay.
or an N2 notice of partial increase, or the act does not apply to these increases. Now, in order to serve that notice, you must serve it 90 days before the date it becomes effective. And the rent amount, the increase amount must be per the guideline increase set by the ministry.
Okay.
And this guideline increase for 2024 is 2.5%.
Okay.
So landlords, if you're looking to increase your rent for 2024, you can do so by 2.5%. Now, many landlords may not think that this is high, but if you compare it to the last 5 or 10 years, 2.5 is actually on the high side.
It is. It is.
So definitely go out and increase the rent if you already haven't done so.
No, it is. And there's a lot of misconception. People assume when they are on a communication with the tenant, they could just text it, they could just WhatsApp it or email it, and then that's not the way to go about it, right? Because
That's
it's
right.
not an actual service.
That's right. So using your smartphones, taking sending a text message or sending a WhatsApp, like you said, or a Facebook message or an iMessage, any type of message is not a legal form of increase. Meaning that if you do it and the tenant does not increase the rent, then you have to start all over again. You already wasted X amount of time.
Okay. So what happens if you send it and then the tenant acknowledges it, they agreed to it? Does that consider it lawful stuff?
It's still not a lawful way to notify, right? So here's the thing. Let's say, for example, you're the tenant and I'm the landlord, and I send you a text and I say, I don't know, April 1st, your rent is going to be increased. And you say no problem. And April 1st, you pay the increase, and May 1st, you pay the increase. And then in month number 10, come next January, one of your friends says to you, hey, Shan, that's not a legal way to increase your rent. The landlord didn't legally increase your rent. You, as a tenant, have the lawful right to file an application with the Landlord and Tenant Board for an illegal rent increase.
Oh, okay.
In which case the board will hold a hearing, and they will usually, on this type of illegal rent increase, they will order the difference back to the tenant.
Oh, wow. Okay.
Yeah. So remember, you want to do things as a landlord, you want to do it lawfully,
Okay. Okay.
especially when it comes to rent increases. There's actually a section of the act that says if a rent increase is paid for 12 consecutive months, if an illegal rent increase is paid for 12 consecutive months, that illegal rent increase is void.
Well,
So if you've been paying that for 12 consecutive months, and then in month number 13 or 14, you find out that that's an illegal rent increase, the fact that you've paid it for 12 consecutive months, it voids being an illegal rent increase.
okay.
So landlords can increase the rent, but if it's done for 12 consecutive months illegally, it's now part of the lawful rent.
Okay, all right. That's a very good point actually, because a lot of people were under that misconception of how to do it, and then it's the easy way to do it through a phone, right? Okay,
That's
that's
right.
perfect. So there's another question that as realtors we face, and then there's these clauses that the agents wants to include. So if in case they find an unauthorized occupant in the house, who is considered an unauthorized occupant, and then does the landlord have the option to evict or terminate the tenancy?
So that's a great question. An unauthorized occupant is someone who's left behind. Usually it's someone who's left behind when the tenant vacates. And this unauthorized person or occupant is not granted permission or not authorized to be there by the landlord.
Okay.
So let's talk about occupants. First and foremost, a tenant and a landlord, the reason why they're referred to as a landlord and tenant is because a tenancy relationship is formed.
Okay.
That tenant is paying for rent, is paying X amount of money for as rent in exchange for accommodations
Yeah.
provided by a landlord.
Mhm.
Okay, that forms a tenancy relationship.
Okay.
The tenant has the right to bring in other occupants.
Okay.
Their parents usually from overseas, their children, maybe a wife from overseas, maybe a husband from overseas, a partner, whatever the case is, their friend. They are allowed to have roommates,
Okay.
okay, without the permission of the landlord.
Without the permission, and then is there a
Yeah.
time duration for it?
No,
Okay.
no. So tenants can have roommates, other occupants, guests, and visitors stay with the tenant without the permission of the landlord. But here's the thing. If the tenant moves out and these people are left behind, they are unauthorized occupants.
Okay.
So long as the landlord had not acknowledged these people as tenants.
Okay.
Okay, so let's say, for example, you're a tenant, I'm your landlord, and you bring in your friend. Your friend needs a place to stay. He was supposed to stay temporarily.
Mhm.
He's now your roommate. And then you get married and you move out, and your friend is left behind. As long as I haven't acknowledged your friend as a tenant, meaning I haven't collected rent from your friend, I haven't taken instructions or direction or served any notices with your friend's information as a tenant, that person is not authorized to be there. Make sense?
Makes sense. Yeah.
So the landlord can now pursue an application for an unauthorized occupant through the Landlord and Tenant Board.
Okay. All right.
Make sense?
Makes sense. So, so the clause that agents put when found when other members found in the family other than the listed parties on the tenancy, so they could really do nothing about it,
It's
right?
unenforceable. That's correct.
Okay, all right.
That's correct.
Okay, fair enough. And then also going back to that, so now there's a trend set out there. So let's say the tenant has a bad credit, or tenant has some sort of a documentation that's not meeting the requirements what the landlord's looking for. Now there is all these landlords and agents asking for anything that's set more than the first and last. So can you pay 3 months, 6 months, or whatever the number of months they have in mind? So is that's not legal, right?
No, so let's talk about that. Illegally, the landlord has the right to request a deposit in the amount of 1 month's rent
Yeah.
and applicable, so applied to the last month of the tenancy.
Mm-hmm.
Okay, that deposit must be applied to the last month of the tenancy. So if the landlord uses it for anything else, for month number 5, for month number 6, if they use it, they lose it.
They lose them.
Okay. Any other deposit, even if it's voluntary, even if the parties agree, whatever the case is an illegal deposit.
It is.
I know that often agents put in their lease agreement, a further
Temporary.
deposit of exactly
Yeah, okay.
voluntary. You see, you can't use certain terms to contravent the act, so to go against the act because we agreed,
Okay.
right? The law is the law, and the law trumps any contract, any lease agreement, any agreement that we have.
So, Beta, let's say tenants applying for it, they put voluntarily paying $1,000, whatever. Could they go back and to the landlord about it, and could they take that money back, or how does that work?
Absolutely. So just like the illegal rent increase, the tenants can file an application with the board for a rent rebate or whatever. And in that rent rebate application, they can claim an illegal deposit to be of X amount to be returned back to the tenant.
Okay, okay.
Right. And all they have to do is really attach a copy of the check or the e-transfer that they gave and a
Mhm.
copy of their lease. There's your evidence at the board.
Okay, okay. Fair enough, fair enough. Because that's a trend set. Every single agent's asking for it, every single landlord's asking for it. That's a trend set now. And
It
as
is.
agents, we really like we get in trouble for implementing. So if a landlord says, "Hey, ask for such," you're not, as an agent, you're not supposed to. What happens then? Do you know?
Well, here's the thing, and you're right. It's common practice that agents ask for this. Okay. What is the landlord hiring agents for? Right? For your expertise.
Yeah.
And I always tell my agents, guys, stand up to your clients.
Yeah.
Let them know what they're doing is not correct.
Correct.
You
This
don't want
happened to
it.
me. I had to
Yeah.
sign grounds, and I said no. It's legal. It's not legal, so I cannot do this on your behalf. Okay, all right.
Yeah. Yeah.
That's a good one. Okay, how about there's also the option when you're evicting the tenants. So can we talk about the steps on evicting, what forms to use, and how could an eviction process take place?
So let's talk about that. Great question. So firstly, in order to commence a legal proceeding, a landlord has to have cause, meaning that they have to have a reason to start a legal proceeding. For example, non-payment of rent,
Okay,
late payment of rent, an application for the landlord's own use, or if the property is sold, the new purchaser's own use.
okay,
Right? These are causes to commence a legal proceeding. So what has to be done first? So firstly, the landlord has to notify the tenant in writing. So they have to serve notice. They have to wait X amount of days, depending on whatever the date of that termination date is in that notice.
okay,
And they have to file with the landlord and tenant board.
okay.
So here's the problem is that, and not, I would say the challenge more so than a problem. The challenge right now is that it takes about 7 to 8 months to get to the landlord and tenant board.
Wow.
Okay, so if you have someone, for example, who's not paying you rent, and you've missed 1 or 2 months rent before you even started that legal proceeding,
Okay.
you're looking at the loss of the 2 months or 1 month or whatever losses that you had, times the amount of time it takes to get to the board.
Wow.
And hopefully there are no issues with your notice or application at the board, because if there are any mistakes, the application will get dismissed and you're
And
going
then
to
you're
have to
back
start
to
all
you're
over.
back to okay.
That's
Wow.
right. So once you get to the board, if everything looks fine, if you've convinced the board, in fact, that the board should order a termination of tenancy, the board will issue you that order.
Okay.
It usually takes 30 to 60 days after the hearing to receive that eviction order.
Okay.
Once you receive that eviction order, then you can go to the sheriff's office, again, depending on the date in that order, and
Mhm.
enforce an eviction. So
Okay.
you go to the sheriff, you pay that filing fee, the sheriff will put you in queue, and it'll take probably about 4 to 8 weeks after,
Wow.
right? So you're looking at about a year's
Yeah.
process just on a non-payment of rent.
And then you can't go back, and the tenant's not going to pay you for that 1 year, right? It's a loss for you.
Well, here's the thing is that the landlord can enforce collections. The thing is, Shan, if you have a tenant who's not working, if you have a tenant who doesn't have any assets, How are you going to collect your money?
That's no good. Yeah, that's no good.
That's right.
Serve anything.
That's right. So you basically allowed this person to you house them for a year.
Yeah, and then that's when this cash for keys and other creative stuff comes in, right? For landlords.
That's right.
Can you elaborate a bit about that?
The cash for keys creative strategy. So cash for keys is basically an offering, so an incentive, a financial incentive offered to a tenant in exchange for a mutual termination of tenancy. Mm-hmm. That financial incentive could be anything. You can offer them 5,000, 10,000, 20,000. You can offer to waive or forgive the rent arrears that they've owed you in exchange for a termination of tenancy. Okay. Usually in 30 to 60 days. 30 to 60. The cash for keys strategy should be executed by a legal representative who's well versed with the law and the strategy. These two things go hand in hand. Because if you're not well versed with the law, then you can't execute the strategy. If you can't execute the strategy, then you're going to have some issues with the law.
Okay. So let's just say a landlord decides to take this process. And the first step would be to reach out to someone like yourself. Hey, Bita, can you help me with this? So what would that next step be?
So what we do is once we have a retainer that comes in, the file usually gets assigned to a member of our team. Okay. That team member would draft a proposal to the tenant and basically negotiate the terms of that proposal or that offer to end the tenancy with that tenant. Okay. Now, I want to say, Shan, because many landlords think, oh, this is extortion. Why do I have to pay my tenant? It's not extortion. It's actually a legal settlement. Yeah. And here's
a quicker one too, right? Rather than
a quicker one, right? So what's the alternative? The alternative is you wait 7 to 8 months. There's no guarantee that the board is going to end the tenancy. Yeah. Hopefully there's no errors. Yeah. Right. So even though you feel like it's extortion, it's a settlement to end the tenancy. Yeah. I mean, if you can't collect from that tenant anyways,
you're not gonna do it.
What's the point?
Yeah, yeah. And then is there a way that you could report these bad tenants? I know that there is sites out there, the one room or something. So how do we report these bad tenants to warn the others?
So a great tool, a reporting tool, or even a vetting tool, because 95% of these headaches can be avoided if they were properly vetted. Yeah. Now, a great tool is openroom.ca.
I actually use that.
Right, you use that. Yeah, great. So do I. Use that for my own tenants, and it's great. Openroom.ca gives landlords access to landlord and tenant board orders that have been uploaded to this public website. Yeah. I think right now it's somewhere between 10,000 and 12,000 orders have been uploaded. And if you go on openroom.ca, you can actually type in as a keyword the name of your tenant or prospective tenant, yeah, and see if there are any orders against them that'll pop up. Yeah. So openroom.ca is great. Landlord Credit Bureau or Front Lobby is also a great tool. We're not really promoting these sites. We're just saying which tools.
Yeah, for sure. Yeah. Right. So the Landlord Credit Bureau, so what happens when you report to Landlord Credit Bureau? Let's say the tenant leaves and then you get $1,000 water bill or some sort of a big lump sum of a utility bill. How could you report that?
That's a good question. I'm not quite sure if Landlord Credit Bureau or Front Lobby is for utilities or damages. I do know that you can report unpaid rent arrears. Okay. And you don't even have to have an order. So that's another great site. It basically destroys a tenant's credit.
Oh yeah, for sure.
Right. So that's another tool. Another one is canly.org. Okay. And that's similar to OpenRoom.
Okay. But yeah, I use those too, but I just found out about the credit bureau stuff right now because I use the other two on a regular basis.
The Canly is more government controlled. Okay. Right. But OpenRoom is a public, and Front Lobby or Landlord Credit Bureau also great reporting tools.
Okay. All right. Okay. And so what is considered a wear and tear? Now that you just brought that wear and tear up, what is considered a wear and tear? Because I have had this in the past where glass was broken in one of the windows, and then the agent was trying to be smart and they said, oh, it's a wear and tear. But broken glass is not a wear and tear. Can you elaborate a bit on that?
I mean, that's hard to explain as wear and tear.
Mm,
Um, wear and tear is basically, like for example, walking on broadloom
okay.
and the under padding wears off after a while.
Mhm.
Nails on the walls usually wear and tear, like things that happen to a product or to something after extensive use.
Okay.
Okay. Now, if we're going to talk about wear and tear, we should probably hit on damages as well. And damages have to be willful, meaning as a tenant, for example, I take a hammer and I smash the
Okay.
granite
Yeah.
countertop.
Okay.
I mean, that's not wear and tear,
Yeah.
right?
Yeah. Yeah.
That you can't take a part of the granite out and replace it. No, you got to
Fully.
replace the
Yeah.
entire, yeah. Even a
Or
broken window.
they punch through a wall or
That's
something.
right.
That's okay.
That's right.
So that's something that's done purposely. It's not wear and tear.
Exactly. It's willful.
Yeah.
Now, for willful damages, the landlord can actually go after the cost of the repair or the replacement after the tenant.
Okay.
The thing is, Shan, remember, now you have to serve an application, a notice, you have to file an application, you got to wait X amount of time to go to the landlord and tenant board. In the meantime, you can't just leave the property with a broken window.
Yeah, sure.
Right? So in the meantime, the landlord has to cough up the costs of the broken window or of the broken, whatever's broken.
So it's 90% of the time, all the landlords feel it's not a landlord tenant board thing. It's mainly a tenant board because landlord are never in a favor of these, right? So let's just say if a tenant decide not to pay your utility bills and whatnot, but as a landlord, you are still obligated to pay all those bills, right? For them to live there. Is that right?
It is. So as a landlord, the thing is that what option does a landlord have? So if they don't pay the water bill, it goes on your property taxes.
Yeah.
Right? So one way or another, though that utility bill company is going to get paid.
Mm-hmm.
But I want to touch on, as you mentioned something, they call it the tenant board, right? Instead of
Yeah.
landlord tenant board. Now let's talk about that because many people think, and I'm a landlord myself, so
Yeah.
many people think that the laws are all for the tenant. Everything is all for the tenant. And let me clarify, that's not the case.
No.
The law, let me explain this. The law provides a balance for both sides.
Okay.
Okay, so 5 years ago, Shannon, if you were to come to me and say, my tenant is not paying rent, we would serve a notice, we would file with the board, and in about 60 days, we'd be in front of the board. In about 30 days after that, so in about day 90, that tenant would be evicted.
Okay.
So the loss to you would probably be a couple months' rent.
Months, yeah.
Right? So here's why many people think the laws are all for the tenant. It's not the laws that's for the tenant. It's the system that is broken. Because right now, by the time we serve notice, by the time we file the application and proceed through the board, the losses to you are about minimum
Yeah.
8 to 10 months.
Mm-hmm.
That's
Is it due to the COVID backlog or is it
we're still feeling the ripple effects of COVID. Yeah.
wow.
So it's not necessarily that the law is broken. It's that landlords fall victim to the broken system because the law doesn't say tenant don't pay your rent.
Yeah.
It doesn't say tenant go ahead and damage the property.
Mm-hmm.
Right? So I hope that provides clarity for all of our
Oh
viewers.
yeah, for sure. And then so let's just say if any viewers were supposed to reach out to you in any sort of eviction or any sort of serving notice. So let's say I decide to serve an or can we also elaborate a bit about N11, N12, and N13 just so that a lot of people have a confusion between those forms?
Absolutely. So many people ask me, what is the difference between an N12 and an N11?
Mm-hmm.
So let me clarify. The N11 is an agreement to end the tenancy. It's a mutual agreement. It's a mutual release. The N12 is a notice. Okay, so it's a notice for the landlord's own use or for the new purchaser's own use. Here's the major difference. Okay, so the major difference is that on an N11, the board will issue an eviction order without a hearing if an application is filed.
Okay.
On an N12, because it's a notice, it says in the N12 that the tenant does not have to move out.
Okay.
Meaning that the landlord has to file an application, a hearing has to be held, and the board will make that determination as to whether or not the tenancy comes to an end. That's the major difference.
Okay.
One is a notice and one is an agreement.
Okay. So
Okay.
so when you serve an N11, let's say it's a mutual agreement, but so both parties sign it. So we still have to file it. You're not just keeping it in your drawer. Is that right?
Exactly. Keeping it in the drawer is no good.
Okay.
Honestly, it's as good as toilet paper because you can't enforce an N11 on its own.
Okay.
And if you actually wait, it expires 30 days after the termination date.
And then it, okay.
That's right. So the N11 on its own is no good. It needs to be filed so that the board can issue an order for enforcement.
Okay. And then for the N12, it is for reasons such as landlord moving in. And so can you talk a bit about that?
Yes, the N12 is a 60-day notice to end the tenancy because the landlord wants to move in, or their child parent or caregiver, or the property is sold and a new purchaser or their child parent or caregiver want to move into the property.
Okay.
Okay. The N12 has certain requirements.
Okay.
In accordance to section 48(1) of the Act, compensation must be paid to the tenant.
Okay.
Whether or not they move out.
Okay.
And remember, that is a requirement.
Okay.
That N12 has to be filed with the board. It has to be backed up by evidence, right? And the board will make that determination whether or not to end the tenancy.
And then the N12 has to, is it true that the N12 has to be served after your 12-month, or you anytime you decide, let's say a tenant moves in, they're 10 months into the lease, and then when do you get to serve the N12? Is it after the 12 months?
So the N12 can be served, but the termination date has to be the last day of the lease term, okay? Or the last day of the rental period if the tenancy is a month to month.
Okay.
Okay.
And then and also if let's say N12 is served and the landlords or the family member doesn't move, and then you ended up leasing it to another party, the tenants could come back to you, right?
That's right. There are huge consequences on an N12 if it's served in bad faith. Huge financial consequences, meaning that the tenant can come and sue up to 35,000 at the landlord and tenant board, or up to 50,000 or higher through the divisional court.
Okay. So yeah, guys, once you implement it, or if you have any doubts, reach out to Stonegate. Bita is always there. I have used her service before, and she's always one phone call away. Thank you so much, Bita. Thank you for taking this. And if I'm going to leave Bita's information, and then also, Bita, you also give out your package or the information guide, right? So how could people access that?
People can access that actually through our website, stonegatelegalservices.ca. They can download our free copy of the Landlord Mastery Guide. And they can also, our contact information is all over our website and social media at Stonegate Legal Services. And you can also book a consult or a discovery call right off of our website.
Perfect. I actually have your landlord mystery. I have downloaded it. I use it. It's a very useful tool, and hopefully people could reach out to you, and you could help them out with their thing. Thank you so much, Bita. Thank you.
Thank you so much, Shan.